Good evening, students. Welcome back. So we will first revisit what we have done. So we have a question by Sakshi Sengar. In Article 15, Clause 4 was already mentioned about admission, education, okay, by referring Article 29B, 29 Clause 2 actually. So then what was the need to add Clause 5 regarding the same? Also, why is Article 19(1)(g) mentioned? First thing is, Article 15 Clause 4 is a general clause. Okay, state can make any special provision for the advancement of socially and educationally backward classes and SC/ST. So, for the sake of what you call explicit provision in the constitution, even before what you call OBC reservation came through this Article 15 Clause 5, even before that there was SC/ST reservation, okay, in University of Delhi and other places, okay. But that provided for a specific provision. So they, for educational institution, the party which came to power at that time had this conception ki theek hai, we will specifically be granting for other backward classes, because already for SC/ST there was reservation in higher education. So they specifically wanted to do that. And also why Article 19 Clause 1 subclause G is mentioned. Reason being, Article 19 Clause 1 Clause G is right to practice any trade, occupation or profession. Okay, so this is also related to, for example, any medical or chartered accountancy or any what you call anything, any education related to a professional education. So if reservation is provided into that, so it will not hamper somebody's fundamental right. Okay, so that Article 29, Article 19 Clause 1G, because 29 may be in educational institution which is fully financed by the state. Okay, no what you call discrimination can be made on the basis of religion, race, caste. So that is an exception. 19(1)(g) professional qualification, there can be reservation. Of course, in chartered accountancy, you don't have any provision of reservation. And also they wanted to explicitly provided, so that is why they added Article 15 Clause G. Okay, so this is the thing. Now, so Article 15 Clause, okay. Now, good evening, good evening, good evening. How are you, sir? I am good. Actually, I am not good. So, sir, please once again, clause for love the way you teach. Okay, thank you. Sir, you can briefly explain. Doctrine of waiver. Doctrine of waiver says that you can waive your fundamental right. Okay. So the Supreme Court has ruled that doctrine of waiver is not applicable in fundamental rights. You cannot waive your fundamental right. Jaise you cannot say, okay, I am waiving my fundamental right, treat me with untouchability. So you cannot waive your fundamental right. Getting? That is the provision. Waiver of rights. एक चीज मैं खुद डिस्कस करना चाह रहा था, हिंदू माइनॉरिटी. ओके, एक्चुअली द केस दैट इज गोइंग ऑन, सो गवर्नमेंट हैज फाइल्ड एन एफिडेविट, अ न्यू टर्न हैज टेकन प्लेस. गवर्नमेंट से हमने कब मना किया था? दे हैव टेकन अ न्यू एफिडेविट इनटू द सुप्रीम कोर्ट दैट states are free to identify linguistic minorities. So actually this is a stand. Why is the case going on? Why the government has to file an affidavit? Why is the case at first place going on? Because there is religious minorities are not determined so on the basis of state. So Hindus are minorities in many states, Arunachal Pradesh, Nagaland, Mizoram, Jammu and Kashmir, many states. They are minorities. So in that sense, that is why the petition was filed in Supreme Court. Now the government has filed an affidavit. Whenever there is a petition, government will file an affidavit. Why government will file an affidavit? Because you have to hear the views of both the sides, na? What is principle of natural justice? ऐसा चेहरा बना लेते हैं जैसे पता नहीं क्या मैंने पूछ दिया हो कि मार्स के थर्ड ब्लॉक में पानी कितना मिलीमीटर पाया गया. हाँ, बताइए क्या है? What is what you call when we talk about that religious minorities? Okay, so religious minorities, as if now they are not, there is one aberration which the government says that Jews have been identified as religious minorities in Maharashtra. National level pe to Jews have not even been identified. Now the case is going on in Supreme Court. Now the government also files an affidavit because you have to hear the views of both the sides. Principle of natural justice is a principle which is followed in all judicial dispensation. कोई भी adjudicatory mechanism होगा, मतलब any mechanism which is deciding over a dispute, it has to follow principles of natural justice. Said, unsaid, it is one of the most important principles of justice everywhere. So what is the most important principle of justice? That is principle of natural justice. And what are the three elements of principle of natural? आप तो बता दीजिए. First, both the sides audi alteram partem, both the sides must be heard. So you cannot give a decision just by hearing one party. Second, everybody has a right to fair trial. And third, nobody can be a judge of his own cause. So I cannot adjudicate upon a dispute in which I have an interest. So these are the three basic principles of natural justice, which is not written anywhere, any book, but these are followed. Even I'll give you a classic example. Aam Aadmi Party MLAs were disqualified on the opinion under, Office of Profit. We'll see that. So they were disqualified on the opinion of Election Commission of India by the Honorable President of Indian Republic. Once they were disqualified, then what happened? When they were disqualified, actually, the Aam Aadmi Party MLAs went to Delhi High Court, claiming that whether Office of Profit they were holding or not, that is a secondary issue. Issue is कि when Election Commission, Supreme Court times and again says, when Election Commission is deciding over a disqualification petition, it is acting as a quasi-judicial authority. So every quasi-judicial authority must adhere to principles of natural justice. Why the views of Aam Aadmi Party MLAs were not taken before giving a view to the President? So it was not decided, the High Court never dwelled into whether they were holding Office of Profit or not. This is a secondary question. First question is कि when Election Commission was deciding over a disqualification, ऊपर से जा रहा है क्या? हाँ, तो बोलिएगा ना, पता कैसे चलेगा? सुनिए, एक बार हिंदी में फिर इंग्लिश में, ठीक है? एक चीज होती है, एक अमरूद है जिसका नाम है ऑफिस ऑफ प्रॉफिट, ठीक है? आई विल स्पीक इन इंग्लिश ऑल्सो, पहले हिंदी में समझा दूं. एक अमरूद है जिसका नाम है ऑफिस ऑफ प्रॉफिट, जो उसको होल्ड करेगा, कुछ चीजें को एग्जेम्प्ट किया है, उसको छोड़ के जो भी होल्ड करेगा वो एमएलए एमपी से डिस्क्वालीफाई हो जाएगा. ठीक है, इतना तो समझ गए? इसमें कोई डाउट है? जो भी ऑफिस ऑफ प्रॉफिट होल्ड करेगा वो एमपी या एमएलए बना है तो डिस्क्वालीफाई कर दिया जाएगा उसको. ये समझ गए? अब ये डिस्क्वालिफिकेशन करेंगे प्रेसिडेंट या गवर्नर. स्टेट में गवर्नर, सेंटर में प्रेसिडेंट. चूंकि दिल्ली में, यूटी में प्रेसिडेंट, आई स्पीक इन इंग्लिश ऑल्सो, नोबडी शुड हैव अ कंप्लेन. ओके, सो जो कि दिल्ली में प्रेसिडेंट अपॉइंट करते हैं चीफ मिनिस्टर और काउंसिल ऑफ मिनिस्टर्स को, तो प्रेसिडेंट ही डिस्क्वालीफाई करेंगे. इसमें डिस्क्वालीफाई करते हैं प्रेसिडेंट या गवर्नर इलेक्शन कमीशन के ओपिनियन पे, बाइंडिंग ओपिनियन. जो इलेक्शन कमीशन बोलेगा ये होल्ड करता है नहीं करता, उसी ओपिनियन पे वो डिस्क्वालीफाई करेंगे. 23 आम आदमी पार्टी एमएलए को डिस्क्वालीफाई करने का इलेक्शन कमीशन ने रिकमेंडेशन दिया प्रेसिडेंट को. प्रेसिडेंट ने डिस्क्वालीफाई भी कर दिया. सारे एमएलए दिल्ली हाईकोर्ट चले गए कि ऑफिस ऑफ प्रॉफिट हम होल्ड कर रहे हैं कि नहीं, ये तो दूसरा सवाल है. जब इलेक्शन कमीशन ने ओपिनियन दिया प्रेसिडेंट को तो हमारे व्यूज क्यों नहीं लिए? तो इसका मतलब इन्होंने प्रिंसिपल ऑफ नेचुरल जस्टिस का वायलेशन किया कि बोथ द साइड्स को सुनना था. इसी ग्राउंड पे सारे एमएलए के डिस्क्वालिफिकेशन को सेट असाइड कर दिया दिल्ली हाईकोर्ट ने. ऑफिस ऑफ प्रॉफिट होल्ड कर रहे हैं कि नहीं, ये दूसरा मेरिट का केस है, लेकिन प्रिंसिपल ऑफ नेचुरल जस्टिस फॉलो होना चाहिए. और जब इलेक्शन कमीशन कोई भी मुद्दा पे फैसला कर रहा है, इट इज एक्टिंग एज अ पार्शियली जुडिशियल अथॉरिटी. सो नाउ आई विल बी रिपीटिंग इन इंग्लिश दैट देयर इज अ गुआवा कॉल्ड एज ऑफिस ऑफ प्रॉफिट. ओके, सो इफ आई एम एन एमएलए और एमपी, if I am an MLA or MP and I am at the same time I am holding an office of profit, then I will be disqualified to be an MLA and MP. So disqualification is done by the president and governor, but opinion is given by Election Commission of India and opinion is binding. So 23 Aam Aadmi Party MLAs were accused of holding an office of profit. वो legislature के भी part हो गए, executive के भी हो गए. They became part of both. Separation of power was violated. So 23 Aam Aadmi Party MLAs were disqualified by the president on the recommendation of Election Commission of India. They moved to Delhi High Court. Office of profit is a secondary thing. Whether they were holding or not, it will be decided on the merit of the case. Why the opinion was given without taking their stand? Since it was a matter related to them, so their opinion should also be considered. Okay, getting my point. So Aam Aadmi Party MLAs, their opinion was also not considered before by the Election Commission when they gave recommendation. On this ground only, Delhi High Court set aside the disqualification. को null and void घोषित कर दिया. Declared null and void. Why? Because principle of natural justice is not written in the constitution, but it must be followed in every judicial act. Act matlab Hindi, ACT small letter act. Every judicial act, principle of natural justice should be followed. And what are the three cardinal principles of natural justice? One, nobody can be a judge of his or her own case. Second, you must hear both the parties before arriving at a conclusion. And third, everybody is entitled to a fair trial. So isi bunyad par, on this basis only the MLA. So principle of natural justice is the basic structure of the constitution. That is doctrine, principle, whatever you call it, is a basic principle. It is not written in the constitution, but it must be. So Hindu minorities pay, why the case is pending in Supreme Court? If they are already declared as minorities in state, there is no need to file a case. So if a case has been filed, it means, कि they are not declared, there is a dispute. So now latest government's views will be taken or not. So union government has filed an affidavit that we don't have an objection. State may go ahead and file a affidavit. Okay, state may go ahead and declare them as religious minorities on state basis. Linguistic minorities are not determined on state basis. Are determined on state basis, not on central basis. Okay, so this is what I wanted to convey. समझ गए? So let's wait what the court says. Okay, Hindu minority, as if now linguistic minorities are determined on state basis. और फायदा क्या होगा once they are determined? We'll see in Article 30. Right to equality has such exceptions. Yes, of course it has exception. Article 361 of the Constitution. President and governor, they shall not be subjected to any criminal, what you call trial or anything, till the time they are holding the post of president. So this is an exception. There are, for example, anybody who is enjoying a diplomatic immunity, so they will not be arrested or anything will not be. If they commit whatever offense they commit, they will be asked to leave. There was an case related to some diplomats of Saudi Arabian embassy. So they were found in some cases against sexual harassment at Gurgaon. So all of them were asked to leave. So they are enjoying absolute immunity in other country. This is as per Vienna Convention. All the countries came together and agreed to this. Okay. Next is Article 15. Sir, please explain what you call. अब तो सारे आर्टिकल एक एक करके लिख रहे हैं, ठीक है. प्लीज एक्सप्लेन टीएमए पाई केस. टीएमए पाई वर्सेस स्टेट ऑफ कर्नाटका इज अ केस रिलेटेड टू डिक्लेरेशन ऑफ माइनॉरिटी. टीएमए पाई एक्चुअली महिपाल अकेडमी ऑफ हायर एजुकेशन, माहे, so they actually own. We'll see this is a case related to Article 30. Okay, we'll see doctrines also, don't worry. Why right to property has, sir, why the right to property has from FR? Actually this is the question, sir, why the right to property has from FR has been deleted from FR. We have not read Article 19. Robot also will speak, so he'll start with 1 2 3 4. I started 1 395. हाँ, अरे भाई सब्र कीजिए. हाँ, अब मैं मीठा होता है क्या होता है वो मैं नहीं बोलूंगा, ठीक है. What happened to you, son? You are not looking well. I cannot share what happened to me. So no person can be a judge in his own case. Both sides must be. What happened to sir? You are not looking well again. Okay, get well soon, sir. Sir, we are understanding. What is TMFI, sir? Opinion of both should be taken. Okay, sir. Yesterday it is a news that state can also declare religious minorities. यही मैंने कहा अभी कि linguistic तो they are already. Center has no objection in them going ahead and declaring. And this is a very valid demand. I told you that day that this is a very, very genuine, rational and valid demand. Why Hindus will not be declared minority in Arunachal Pradesh, Nagaland, Mizoram, Jammu and Kashmir? It says that 12 states they will be declared minorities. So this is a long pending demand. It is only because of National Commission for Minorities Act 1992 जो सिर्फ central government को empower करता है. Empowers only the union government to declare a religious minority. So this was challenged. Now most probably they will be, now the center has no objection. जब राजी तो क्या करेगा काजी? So getting my point na? So center has no objection, state has no objection, so who will add? Minorities have no objection, so go ahead and declare. Although if Supreme Court declares, undoubtedly it will be under Article 141, every judgment of Supreme Court has a binding value and is equivalent to that of law. You look like Denver from Money Heist. ओके यार मैं बहुत दुखी हूं इसलिए मत ही कुछ बोलिए चलिए ओके सो वी विल रिविजिट फर्स्ट वी डिड आर्टिकल 13 ऑफ द कॉन्स्टिट्यूशन आर्टिकल 13 ऑफ द कॉन्स्टिट्यूशन डील्स विद प्री कॉन्स्टिट्यूशनल लॉज एंड पोस्ट कॉन्स्टिट्यूशनल लॉज प्री कॉन्स्टिट्यूशनल लॉज का मतलब क्या हुआ कॉन्स्टिट्यूशन के आगे चिपकाया जाता है जिनको हाँ those laws which have come before the constitution and post constitutional laws those which have come after the constitution and laws matlab ordinary laws so any pre constitutional law that is inconsistent with fundamental rights shall be void to the level of inconsistency any post constitutional laws that is inconsistent contravening they have used the term ab jana nahi chahte hain warna they have used the term contravene in clause 2 and inconsistent in clause 1 for pre-constitutional laws since they are already into being so you'll use the term inconsistent क्योंकि already जिंदा हैं वो post constitution they will be enacted later so they use the term contravene okay so contravene any post constitutional laws if it contravenes fundamental right it will be null and void to the level of contravention okay then it says पूरा कहानी है कि आर्टिकल 13 में द टर्म लॉ इंक्लूड्स ऑर्डिनेंसेस अध्यादेश वी विल सी बाय लॉज मेड बाय लोकल अथॉरिटी देन यू हैव व्हाट यू कॉल एनी अदर डेलीगेटेड लेजिस्लेशन कस्टम और यूसेज मतलब एक कस्टम है कि whenever a particular person from caste X comes everybody has to stand so this is a custom in government office so this also will be seen as a violation of fundamental right any usage कोई ऐसी practice चल रही है caste based discrimination that also will be so the ambit of term law is very very wide any practice which violates fundamental rights shall be declared null and void okay so this is the crux of article 13 okay sir how can I fill a case against UPSC there should be computer science as an optional so sir please give 10 minute करंट अफेयर्स अब बोलिए कुछ देर में इस पे ये दे विल बी डिमांडिंग सर प्लीज सेल 2 कोल्ड कॉफी एंड 1 फ्रेंच फ्राइज जैसे इन कोरोना देयर वाज ई सेमिनार एंड ई स्नैक्स आल्सो आप लोग नहीं समझिएगा चलिए बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन ओके सो बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन इज अ डॉक्ट्रिन दैट हैज बीन प्रोपाउंडेड बाय सुप्रीम कोर्ट in Keshwananda Sripad Gopala Bharti versus State of Kerala on 24th April 1973. The Constitution of India is resting on certain basic pillars. If you remove those pillars, the edifice of the Constitution shall be falling. Okay, so these pillars must not be distorted under any circumstances. This has been ruled by the Supreme Court and the doctrine is organic in nature. पहले कहा सुपरमेसी ऑफ कॉन्स्टिट्यूशन इंडिपेंडेंस ऑफ जुडिशरी फेडरलिज्म सेक्युलरिज्म रूल ऑफ लॉ रिपब्लिकन कैरेक्टर ऑफ इंडियन स्टेट सेपरेशन ऑफ पावर्स इक्वालिटी बिफोर लॉ राइट टू लाइफ ऑल दीज हैव बीन गेटिंग सेक्युलरिज्म okay secularism in SR Bomai case okay then we ventured into article 14 that is equality before law and equal protection of laws equality before law is in many cases like criminal laws whoever commits an offense is equally subjected to the criminal laws of the land so equality before law would be in many cases and equal protection of laws also would be there so equal protection of laws permits बस एक ही वर्ड दुनिया में आएगा और कुछ नहीं दो वर्ड का कॉम्बिनेशन है permits positive discrimination or reasonable classification so any classification that is done by the state यही 2021 का क्वेश्चन है This was the question of 2021 चार लाइन का एकदम जैसे ही 4 लाइन they write immediately understand this is the easiest question on earth okay why because they are trapping जैसे ही you see that the question is very complex, मतलब it is brutally easy. You will read the question twice, you will see इसमें कुछ ना कुछ छुपा हुआ है. A very visible hint would be there. Okay, let me see if I can bring those questions someday and then we'll laugh. Okay. So it gave any law that is made discriminatory in nature, arbitrary in nature, and it's favoring someone, it will be challenged under which article? Violation of. Or 21, 20, 25, 14. 14. So the language was very complex. Answer was 14. Okay, but in examination hall, it is very easy to speak in air conditioned hall, but undoubtedly, if you have a conceptual clarity, कुछ नहीं, 4 से 5 question UPSC is asking conceptual based questions. Okay, so that is Article 14, equality before law and equal protection of laws, reasonable classification and everything. Then you have Article 15 of the Constitution, which prohibits discrimination on the basis of religion, race, caste, sex, place of birth. What is missing? Place of. Did we write on that day? अच्छा लिख लिए थे हम. Okay. कुछ. Okay. So religion, race, caste, sex, place of birth. Okay. So what is missing? Place of. Can there be a discrimination on the basis of place of residence? Yes. What are the other provisions? First, public restaurant, bathing ghats, partly or wholly maintained out of state funds or dedicated to general use of public. State can make special provision for women and children, advancement of SC, ST and socially and educationally backward classes of citizens, and for higher education, SC, ST and other backward class, socially and educationally backward classes in both aided, non-aided, private, excluding minority educational institutions. That is, and finally you have on 8th of January 2019, Minister for Social Justice and Empowerment, Thawar Chand Gehlot, introduced 103rd Constitutional Amendment Act, which provided for up to 10% reservation. Is it a fundamental right? No, reservation is just a provision. It promotes the idea of equality. ये याद रखिएगा, ये कोई, it is not a charity. It is actually promoting substantive equality. So somebody is feeling weak. So if you are offering juice or any substantive meal, so you are not helping that person, actually making that person to be at par with others. So that is the principle of substantive equality. Okay, so that is the provision that is there in Article 15 clause 6 about with respect to economically weaker section up to 10%, not by law, by a provision. So just by incorporating Article 15 clause 6 in the Constitution, economically weaker section would get reservation in state public service commission. No, it is a provision. Both the state and union have the liberty to come out with a notification. So once Article 15 clause 6 was added, all the states in India came out with their own notification and then they implemented 10% reservation for economically weaker section. So just by providing something in the Abhi Justice G.Y. Chanchud made a very remarkable remark in last month, December actually, 2-3 months back. So he made a remark that Article 16 or 15, these provisions of reservation are not exception. अब देखिए कितनी बड़ी बात कह रहे हैं. Article 15 says that there can be no discrimination on the basis of caste, and later on it says that socially and educationally backward classes and SC ST can be provided reservation. So it is settled कि पहला का last वाला exception है. First is saying no caste based discrimination. Next it says कि caste based reservation can be given. So it is an understood phenomena कि it is an exception to the first it says that there will be no discrimination on the basis of sex. Next it says that women and children, there can be special provision. You're getting my point. So it is understandable ki, or it says for general provision and also for higher educational institution. Justice Chandrachud said ki nahi, ye jo niche jo provisions hai, these provisions are not exception. Actually they are promoting the principle of equality. Don't think as a charity, simple language mein, don't think that this is a charity. Actually, this is promoting the entire cause of equality. So this is, they are here, so it must be given so that they come here, then there would be equality in the society. Okay, so equality in true sense, which includes the principle of equity. So it is not an exception. Okay. Bylaw is made by a local authority. Reasonable classification, positive discrimination, and then we will be starting with Article 16 of the Constitution. Okay. पीछे जो है वो उन लोगों को समझ में आ रहा है भाई? Backbenchers? What is the time you are required to come to get this front coveted seat? Huh? 3:30. Huh? 4:30. और उसमें कुछ ये नहीं होता है ना, आगे पीछे कुछ पता चला SHO करोल बाग is coming to allocate seats. Okay. Okay, so we have Article 16 of the Constitution which says there shall be equality of opportunity for all citizens. एक चीज clear हो गई. What? This fundamental right is applicable only for citizens. Non-citizens cannot claim equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matters related to employment or appointment to any office under the state. So in public employment, there shall be equality of opportunity. On what grounds discrimination is prohibited? No citizen shall, on the grounds only of religion, race, caste, sex, descent, place of birth or residence. So what are the additional grounds? That is descent and residence. Actually, it is descent in the sense ki domicile. Okay. So you can have only one domicile. For example, देखिए, domicile is actually applicable in reservation. So you can be, first of all, there is a different OBC list. Central SC list is uniform. SC can only be declared by the Union Presidential Order, which has to be amended by the Parliament. So Article 341 of the Constitution, there is a uniform SC list. For ST, Article 342 of the Constitution. For OBC, Article 342, capital letters A, there can be a central OBC list and state OBC list. So may be possible that you have made two domicile. So if you make two domiciles, you very likely that you may have a home at Delhi and also at your native place. So you will get the benefit of state PSC reservation in two states. So that is not possible. So for that, for reservation, they take certain cutoff date. People who of a particular caste, when did they come into the state? That's a very complex analysis. Okay, there is always a politics going on that it should be very, what you call before or very recent. If you make it recent, more people will be included or less? More people. If it is made 1932, there would be 4 people. If it is made 2015, whoever has come after 2015, so there would be less people. So always there is a politics that you should make the cutoff date. In Jharkhand, there was a actually issue. Make it very, very 1932, so that most of the people have come after that, so they will not get. You are getting my point. So itna hame nahi jana hai. What we need to know that in matters of public employment, RRCSP, religion, race, caste, sex, place of birth, place of residence and descent. On these basis, discrimination cannot be allowed. Okay. Then it says that nothing in this article now shall prevent the parliament from passing any law in regard to class of employment to an office, providing residence within that state or union territory to such employment. Ab suniye. This is a very important line. There is a UPSC and there is a State Public Service Commission also. There are state government jobs and there are union government jobs. ऐसा तो नहीं है कि Monday, Tuesday, Wednesday I am working for union government, Friday, Saturday, Sunday I am working for state government. ऐसा तो नहीं है. Either you are union government employee or state government employee. So now, no state can. So on what ground place of residence and descent cannot be a reason for discrimination? Getting my point? So Can the state prescribe residence as a criteria for certain classes of employment within the state? Huh? Going by the constitution, what it says? What is the constitution saying? Just read. In public employment, what cannot be a ground of discrimination? In public employment, what cannot be a ground of disqualification? Yeah, discrimination. Huh? So, place of residence, this is permitted ground or this is prohibiting discrimination? Prohibiting. ये सामने है. This is right before you, that there will be no discrimination on the basis of place of residence. Okay. So place of residence cannot be a ground of discrimination. Crystal clear hai? Next point is कि if the place of residence cannot be a ground of discrimination, can the state reserve a particular employment only for the residents of that state? No. Never. Actually, many times, although the state all the time keep on trying and it is declared unconstitutional by the Supreme Court. Recently, there is a controversy related to Haryana State Legislative Assembly reserving certain classes of employment only for the residents of that state in private sector. In private sector. Okay, it is not in, here it is written in public employment. Many states in the past have also attempted to give certain advantage to the candidates from the state, but all of the such attempts have been declared unconstitutional because residence cannot be a criteria in public employment. So this provision was incorporated by the founding mothers and fathers of constitution, keeping in mind that otherwise every state will reserve all its job only for the residents of that state, and then it will lead to balkanization and it will be detrimental to idea against Article 19(1)(d) right to travel and Article 19(1)(g) right to practice any trade, occupation or profession. So this will be against that. Now the point is कि if parliament feels, parliament can prescribe residence as a criteria for certain state or UT government jobs. Now you think, if for example there is a state of Andhra Pradesh, it is Andhra Pradesh Public Service Commission or any other public service commission, UP Public Service Commission or Madhya Pradesh Public Service Commission, if it wants to reserve certain job only for the residents of Madhya Pradesh, then this will be done by parliament, because whenever parliament will do, it will keep the national integration in mind. So parliament can prescribe residence as a criteria for certain classes of employment within the state or union territory. अब आप समझ रहे हैं? State cannot do that. So parliament, there was all such residence criteria has been done away with. Only parliament has enacted one law for certain places in Andhra Pradesh, certain jobs were group CD normally, because if those areas are extremely backward and group CD jobs also are taken by somebody from the outside, then what will happen? What will happen? If group CD jobs are taken by somebody from the outside, then what will happen? Then the people, local people already do not have employment opportunities. Thank you. So do not have employment opportunities. Then what will happen? They will already, somebody from outside will take the job. So if parliament feels, as a national integration keeping in mind, parliament can prescribe residence as a criteria for certain employment in the state or UT. यानी state और UT की job में वहीं के लोगों को आरक्षण मिलेगा कि नहीं, इसका अधिकार पार्लियामेंट को है. स्टेट लेजिस्लेटिव असेंबली को अधिकार नहीं दिया गया, अदरवाइज सारी स्टेट लेजिस्लेटिव असेंबली अपनी सारी जॉब्स जैसे पार्लियामेंट को इसलिए दिया गया अधिकार ताकि पार्लियामेंट पूरे देश का हित एक साथ सोचे. ओके, सो स्टेट लेजिस्लेटिव असेंबली हैज नॉट बीन गिवन पावर टू प्रिस्क्राइब रेसिडेंस एज अ क्राइटेरिया फॉर सर्टेन पब्लिक एम्प्लॉयमेंट. Parliament can prescribe residence as a criteria for certain public employment, which it does very rarely, and that too for group CD jobs. So whenever parliament will do, it comprises of the entire country, so it will take all the factors in mind. You are getting this? So it says nothing in this article shall prevent parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government or any local or other authority, a state or union territory, any requirement as to residence within that state or union territory prior to such employment. So residence can be a criteria for certain classes of employment within the state or union territory. समझ रहे what I am trying to say? Parliament will prescribe residence as a criteria for central government jobs or state government jobs. State government की job में parliament वहीं के लोगों के लिए seats reserve कर सकता. Parliament can reserve seats for the, but this will be, so if the power is given to parliament, parliament will not provide any such thing until it is extremely necessary. For example, there is a hilly state, so multinational corporations would not make an investment. For example, if you open an Infosys office in Uttarakhand hinterland, so how will the employees reach? So the investment will not be there. So job opportunities predominantly would come from government sector. And if those jobs also are taken by people from outside, then what will those people do? So parliament can prescribe residence as a criteria for certain classes of employment within that state or union territory. This power has been given to parliament. Not, this can be a question in prelims as well as mains. Okay, आगे कह रहा है, now nothing in this article shall prevent the state from making any provision for the reservation of the appointment or appointment in favor of any backward classes of citizens which in the opinion of state is not adequately represented in the services of the state. This adequate representation has been one of the biggest headache for Supreme Court. यानी कोई भी इस आर्टिकल, nothing in this article shall prevent the state, state मतलब the definition of state in article 12 including both union government and state, can make laws for reservation for certain classes of employment which in the opinion of state are not adequately represented. So ye bahut hi important, you are getting this, very important. Now one thing which you must understand, iske aage kuch one ya kuch laga hua hai? No, nothing is. So it means it is part of original constitution. It means reservation in public employment was part of original constitution, while other reservation, SC ST scholarship or higher educational institution, any other thing has been added later, but for public employment it was there in original constitution. क्या कह रहा है? Which shall prevent the state from making any law for reserving certain appointment or post in favor of backward classes of citizens. So yani in favor of backward classes of citizens, yani backward classes of citizens कौन? Which in the opinion of state is not adequately represented. State को ऐसा लगता है कि they are not adequately represented. Now this is one of the biggest headache. How will you say that they are not adequately represented? I'll give you an example. Community X is OBC in certain states, but in central OBC list they are not OBC. So in 2014, before elections, that community was included in central OBC list, and for prelims exam they came under OBC. So once they appeared for prelims, so prelims they were counted in OBC and they were invited for mains. By the time mains results came, this was challenged in Supreme Court that this community is relatively better off, so they should not be included in OBC list. So the Supreme Court asked only one thing from union government, that this community is not adequately represented in the eyes of the state. How did you arrive at a conclusion overnight? Do you have any quantifiable data to prove that this community is less in IAS, IPS? Or do you have any data that this community is relatively backward? Okay, so you are getting my point. And again, when the mains results came, they were back to general. Okay, so फिर से general हो गया. So getting my point. So this is something. So whenever reservation is given, it has to be proved that this community is not adequately represented, and there are 50 such cases where the Supreme Court checks that on what quantifiable data. दो चीजें चेक करनी है. First, the community is socially and educationally backward on a general basis. Illiteracy, infant mortality, inequality, access to economic resources, how many, what you call households, other, you get all the information. And next, whether they are adequately represented, quantifiable data कि government jobs में इस community से कितने लोग हैं, how many people are there from this community in what you call in government jobs, then only they will be given reservation. So what you need to remember is the community should not be adequately represented in the eyes of the state. Getting my point? So what article 16 पहले कह रहा है, article 16 no discrimination on the grounds of religion, race, caste, sex, place of birth, descent and place of residence. Later on says that कि parliament can prescribe residence as a criteria for certain classes of employment within the state or union territory. You're getting it? If parliament will do that, parliament will be absolutely impartial. Not in central government jobs. It is for everyone. But in state government jobs, who will make residence as a criteria? Parliament. Next, it's in the next part, it says that if they are not adequately represented in the eyes of the state. Agar ab ye jo hai, ye, this is a big dahi bada. Adequate representation has seen so many cases that whether the community is adequately represented or not, how this can be proved. Because this is reservation at times is also due to politics, reservation, elections and all. So many a times a community which is relatively better off is also provided reservation. So the state fails to prove this, that whether it is adequately represented or not. Is there a commission or backed by a data or any such thing? Getting my point? So समझ रहे ना इसको? Now it is, we will see this article 4 है, अभी छोड़िए इसको, ठीक है? इसमें कुछ भी नहीं है, बस लास्ट देखिए 5. A मैंने कहा था A जब भी होगा, so 4 में they have added 4A and 4B. So 4A 4B means it has been added later on, 77th and 85th constitutional amendment. Now article 5 says, sorry, 16 clause 5 says, nothing in this article shall affect the operation of any law. कोई भी ऐसा law है which provides that the incumbent of an office in connection with the affairs of any religious denomination or any member of governing body shall be a person professing a particular religion belonging to a particular denomination. Now, for example, there is a Waqf board. So, have you heard of Waqf board? So, Muslims, if they die without here, or they want to give property for the charity of their community or any such property which is related to religious denomination. For example, Amarnath Shrine Board is there. Getting my point? For example, Gaya Temple Trust is there. For example, there is a Waqf board is there. For example, there are other such properties also there. Any other property or any denomination or any particular religious thing, anything. You are getting my point, na? So religious thing is there, temple, trust, or any office related to that, or dealing with a particular religion or sect of it, that is denomination class. Okay. So now the point is, a person who follows that religion, he only will be appointed. And it will not be a violation of Article 16. For example, there is a Waqf board. The chief executive officer of Waqf board shall be a state PCS officer in some states. In some states it is IAS. So he will be a Muslim. So this will not be seen as a discrimination on the basis of religion. For example, there is Amarnath Shrine Board or Hajj Committee of India. Appointment is made by the government of India. But the person who is appointed as the CEO of Hajj Committee, presently he is an IRAS officer in a railway account services, he is a Muslim. So if he is a Muslim, so only if Muslims are appointed to such post or Hindus are appointed to such post, it will not be seen as a discrimination. So those offices which are related to religion or religious denomination, only a person professing that religion, any religious, nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religion or denomination or any member of governing body shall be a person professing a particular religion. उसी मजहब के व्यक्ति को उसी गवर्नमेंट के पोस्ट पर डाला जाएगा and it will not be seen as a, you are getting my point. So there are certain, in India religion is deeply, state is deeply involved, na? So Amarnath Shrine Board, Hajj Committee of India, Waqf Board, many such religious denominations, appointment is made by the state. For example, in Tamil Nadu, the state has taken over many temples and the management or governing body is appointed by the state. So only a person who professes, or example, any shrine or any particular temple or any such thing or religious denomination, a person who professes that religion will be appointed. So this is actually an exception of, पहले कह दिया, अब देखिए कितने exceptions हैं. हाँ? So first you said there will be no discrimination in public employment on grounds of religion, race, caste, sex, place of birth. फिर कहा कि नहीं, कोई बात नहीं. Special provision can be made for socially and educationally backward classes of citizens who are not adequately represented. Then residents को कह दिया, parliament can prescribe a criteria. Then those religious offices which are related to a particular religion, if the state is making an appointment, an officer or any person of the same religion can be appointed. So there are various एक्सेप्शन. बीच में दो और है, consequential seniority and what you call 50% ceiling limit, that we will see now. Okay, ये समझ में आ रहा है? ये you are getting this? You please raise your hand if you have not understood. I'll ask question now. Okay, so on what ground access to public employment discrimination is prohibited? What all grounds? Religion, race, caste, sex, place of birth and place of residence and descent. So 7 grounds, no discrimination. Can the state legislative assembly prescribe residence as a criteria for certain classes of employment within the state government? No. Can the parliament do that? Yes. You are getting that point. Next important point is कि if a particular religious denomination or religious office is there, an officer belonging to that community is appointed and this is provided in a law, will that be okay? Yes, that will be okay. And residence and all thing. Now we see article 340 of the constitution. ठीक है? हाँ, एक सेकंड मैं निकाल लूं. Three. Okay. So, yeah, please ask. हाँ. क्या? डिफेंस सर्विसेज में क्यों नहीं दे रहे बताइए? नहीं, जवाब है, रुकिए पहले बताते हैं. ऐसा बिल्कुल नहीं है. सबसे पहली बात है कि is gender only a ground of discrimination? No. The ground of discrimination is an additional one. Gender is not a ground of discrimination. Certain physical requirement of the job. This actually has been dealt by Supreme Court also. Ki certain, initially they used to say that certain physical what you call requirement and on battlefront. So if women are directly participating on a what you plain note, what about war prisoners? What about war prisoners? So if there is a war and there is a war prisoner, so do you think the consequences? Okay, so that is why they were not employed in the armed forces at the front. Now the article 14 ke ground pe it has been challenged in almost all the services, it has been extended, but the ground was different. It was not because of gender, other reasons were there, and that too was discriminatory. So dhire dhire many other policies are there which are discriminatory. Constitution uses the term he at 100 places. So, but now dhire dhire all these discriminations are going, and women have been what you call moving towards commissioned officer and air force and all the what you call recently the evacuation that happened. So entire women crew flew to what you call Ukraine and what you call those places where they. So of course this is there. So this is the thing. Okay. Now article 340 of the constitution. It says the president may by order appoint a commission consisting of such persons as he thinks fit to investigate the conditions of socially and educationally backward classes of citizens within the territory of India and difficulties under which they work hard labor, and to make recommendations as to steps that should be taken to remove such difficulties and improve their condition, and grant that should be given for the purpose. Simple language mein, article 340 of the constitution empowers the President of India to constitute a commission time to time. Matlab it is not a permanent commission, it is a temporary commission. So look into the C, appoint such conditions within the territory of India and difficulties to look into the conditions of socially and educationally backward classes of citizens. So first of all, you must have heard about Mandal Commission. Okay. So इसी को लेकर okay. Article 16 clause 4 we will again see, don't worry. अभी यहां देखिए, we'll write in. For example, you have, अब सुनिए, whenever the president feels, whenever मतलब whenever, it is a permanent body or it is a temporary body? हाँ, President President may appoint a commission. So here that commission will be temporary or permanent? Temporary. To look into the conditions of socially and educationally backward classes. Okay? Backward classes. So president, you are getting my point. So to look into the conditions of socially and now please be very alert. Okay? Socially and educationally backward classes. So this will be a temporary commission or permanent commission? Temporary commission. Time to time they will be given a mandate. So and then you have article 338B. इसमें नेशनल कमीशन फॉर बैकवर्ड क्लासेस NCBC, ये एक परमानेंट कमीशन है. सो नेशनल ओबीसी कमीशन इज अ परमानेंट कमीशन. इसमें और इसमें अंतर ये बोथ ऑफ देम आर वर्किंग फॉर बैकवर्ड क्लासेस. बट दिस कमीशन यू हैव आर्टिकल 338 फॉर SC कमीशन, SC कमीशन 338A ST कमीशन एंड 338B OBC कमीशन. नेशनल एक्चुअली इसका नाम है NCBC, भिकाजी कामा प्लेस हेडक्वार्टर है. नेशनल कमीशन फॉर बैकवर्ड क्लासेस. दिस वाज एडेड थ्रू 102nd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. This was added through 102nd Constitutional Amendment Act, that is Article 338, Article 338A and Article 338B. अब सुनिए, ये permanent commission है to look into the overall issues related to SC, ST and OBC. What are the constitutional safeguard? If there is a discrimination, they can write a complaint. This is a general commission, which is a permanent in nature and it is a constitutional body. It is not a constitutional body. So एक permanent commission है जिसका काम है look into the welfare of SC, ST, recommend the government, receive any complaint and make recommendations of discrimination, overall constitutional safeguards are implemented or not, whether the state is taking welfare of SC, ST and OBC or not. This is a permanent commission. Now this commission is temporary. ये time to time बनता है किसी एक issue को लेकर के. Okay, you look into this issue. So first such commission was constituted. First such commission was constituted in 1953. So it is called first backward classes commission. So you have first backward classes commission. So first backward classes commission was in 1953, Kaka Kelkar commission. Was it a permanent or a temporary commission? Temporary commission. So and it made certain recommendations, most not implemented, so it is not of much importance. Second backward classes commission was appointed on 1st January 1979, announced on the floor of the house by Moraji Desai government on 20th December 1978. So 1 January 1979 को ये बना. So this is second backward classes commission. This is called as BP Mandal commission. Okay. And third backward classes commission was constituted in 2017, जो अभी काम कर रहे हैं. Every day it is in news. Justice G Rohini commission. So Justice G Rohini commission को 2017 में constitute किया गया. It has been constituted in 2017. What is the mandate of G Rohini commission? Very simple question. OBC को कितना reservation है? 27% sub classification, sub categorization of OBCs. मतलब within OBC, those communities which have larger representation, they will be put under 5% or 4%. Other will be put under 18%, other would be put under 9%. ऐसे ही कुछ classification किया जाएगा. You're getting it? So what is the mandate of Justice G Rohini Commission? Sub categorization of OBCs or 12th extent. Do you think it is an easy task in India to sub-categorize OBCs? There are more than 7,000, 6,000 communities. वो 2011 का census अलग है, don't, उसमें 1 लाख से ज़्यादा है. And 99% communities have less than 100 population. So there is brutal discrepancy. That is why socio-economic caste census has not been implemented in true sense. Demand हो रही है ना socio-economic caste census. So Justice G Rohini Commission is third backward classes commission, constituted under which article? Constituted under which article? Article 340. President की जिम्मेदारी है time to time constitute commission to look into the conditions of socially and educationally backward classes. उसी सिलसिले में, in that direction only, Justice G. Rohini Commission has been constituted to sub-categorize OBCs. Within OBCs, those communities which are eating the larger pie of seats, they will be pushed under 4 or 5%, and other communities within OBC which have less representation. So it is a very tough task in India to actually sub-categorize OBCs, keeping in mind the diversity of India. So ये काम कर रहे हैं और 12वां extension मिल चुका है, 12th time. Okay. अब देखिए इनका शुरू हो गया. Sir, in CLAT I got 63 marks and a boy who was in my class got 0.5 marks. So it is Justice G. Rohini Commission. Okay. Now you have BP Mandal Commission. BP Mandal Commission was constituted to provide reservation for OBCs. Okay. So you are getting, when it was constituted? 79. BP Mandal Commission was first time non-Congress government came to power on 23rd March 1977, when Mrs. Indira Gandhi lost election and Morarji Desai became the first non-Congress Prime Minister of India. You getting this ना? अभी तक कुछ okay, ठीक है? कोई बता देना है भाई एकदम. So you are getting my point ना? So first, Mrs. Indira Gandhi lost power, Morarji Desai became the Prime Minister, he announced Backward Classes Commission. Second backward class, of course the President will notify, but who will take a decision? Government. Wherever you use the term President in the Constitution, most of the places it is Union Government, because Article 74, President shall act on the aid and advice of Council of Ministers. So the government announced that we are going to constitute second Backward Classes Commission, just Mandal Commission. Mandal Commission gave its report in 1980. वक्त लगेगा ना, 1.5 साल लगेगा. 80 said कि around, as per 1931 census, there are 52% of the population of country comprises of OBCs. So they should be given at least 27% reservation. समझ रहे हैं बात को? So first backward classes commission, Kaka Kelkar commission, not of much significance. Third backward classes commission already going on, sub-categorization of OBCs. Second backward classes commission is BP Mandal Commission, that is popularly known as Mandal. He was a member of parliament from Saharsa, Bihar, and briefly chief minister of Bihar also for a month or two. Okay. So this commission said that India mein 52% population is of OBCs and 27% jobs should be given in union government and state governments to OBCs. Okay. The commission was constituted in 79. Morarji Desai government lost power. Then Chaudhry Charan Singh ji became Prime Minister. Elections were announced and 14 January 1980, Mrs. Indira Gandhi again came back to power. 14 January. So by the time the commission submitted the report, the government changed. So of course, most of the time, if the commission is of previous government, you are getting my point. So the report was, it recommended 27% reservation for OBCs. It was kept in back burner. 10 years after, VP Singh ji became the Prime Minister of India, 1990. So on 13th August 1990, he announced that Mandal Commission's report that is pending since 1980, we are going to implement that and provide 27% reservation in union government jobs to the OBCs. Okay, states can also go ahead and provide reservation. After that, states also followed the suit. So the point is, after that, VP Singh government also fell. उनकी भी गवर्नमेंट चली गई, लेकिन अनाउंस तो उन्होंने कर दिया, इंप्लीमेंट तो हो गया. दिस आर इंप्लीमेंट. सो न्यू गवर्नमेंट केम टू पावर ऑफ कांग्रेस गवर्नमेंट. अगेन during the election campaign, Rajiv Gandhi ji was assassinated on 21st May 1991. So after that, Congress came to power. Congress said, okay, 27% for OBC is good. We will also give 10% reservation to poorer sections among general category. So reservation कितना हो गया? You have 15% for SC, 7.5% for ST. Then August 1990, VP Singh government announced 27% for OBC. किसके recommendation पे? On the recommendation Mandal Commission, which submitted report in 1980. यानी 10 साल के 10 years gap. Because by the time the commission was set by Janata Party government, and the commission submitted its report, Congress came back to power. So it did not implement. Again, when the National Front government came, they actually implemented. After that they also lost power and mid-term elections were held in India. 89 के बाद election होना चाहिए था 94 में. It should have been held in 94, but it was held in 91 because governments lost majority. Then in 1991, 10% reservation was announced for poorer among general. Now all these new reservations, they all were challenged in Supreme Court by multiple petitions, huge protest, and a Delhi University student burnt himself. That is one of the famous incidents you can search on internet. So huge protest happened because at that time private sector tha hi nahi. Private sector, either you have to go to a PSU or join a government job. So of course there were huge protests in India. Finally, multiple petitions were challenged in Supreme Court, challenging the validity of 27% OBC and 10% for poorer sections. This judgment was delivered on 16 November 1992, which is called as Indira Sohne versus Union of India. इसमें सुप्रीम कोर्ट ने कहा 27% रिजर्वेशन फॉर ओबीसी is constitutionally valid. Only thing is 27% reservation for OBC is constitutionally valid. Only thing is all OBCs would not get exclude the creamy layer. So पहला सुप्रीम कोर्ट ने कहा okay 27% is valid, exclude creamy layer. जो उसमें क्रीमी लेयर है तो गवर्नमेंट ने क्रीमी लेयर डिटरमाइन करने के लिए टू डिटरमाइन क्रीमी लेयर गवर्नमेंट कॉन्स्टिट्यूटेड अ कमिटी कॉल्ड एज रामनंदन प्रसाद कमिटी. Okay, this is one thing. Second, now to exclude creamy layer, next Supreme Court said that reservation cannot breach 50%. 50% breach नहीं, तो अभी कितना पहुंच गया था? See 59.5, 10% reservation given to the poorer section, poorer among general. Poorer among general is unconstitutional. Supreme Court said nahi. 10% reservation for poorer among general is unconstitutional because Constitution says socially and educationally backward classes. Constitution never says economically backward. So economic criteria cannot be a ground for reservation. What the present government did, कि rather than giving 10% reservation to EWS, added a provision in the Constitution. Last time Supreme Court has declared is unconstitutional because there is no provision in the Constitution provides for economic weaker. So rather than giving them reservation by a government notification or law, this time they added a provision in the Constitution that economically weaker section would be a ground. Next Supreme Court says that there will be no creamy layer for SC/ST. No creamy layer for SC/ST. So for SC/ST there will be no creamy layer. Next Supreme Court says, ये बहुत ही comprehensive judgment है. Next Supreme Court says no reservation in promotion. Okay. So this was declared in Indira Sahni versus Union of India 16 November 1992 कि 27% OBC is valid and creamy layer will be excluded. So government constituted this committee to determine what is a creamy layer. So then you have 50%. Okay, 50% marks. समझ रहे हैं ना? अब 50% and एक और बात सुप्रीम कोर्ट ने कही. To look into the over exclusion and under exclusion constitute a statutory body. So National Commission for Backward Classes Act 1993 was passed. National Commission for Backward Classes. यानी एक परमानेंट बॉडी बनाई है ओबीसी के लिए और it will give recommendation which community should be added and which community should not be added. Now National Commission for Backward Classes was a statutory body. It was created by a parliamentary law. अभी वो बन गई कॉन्स्टिट्यूशनल बॉडी, तो इस नेशनल कमीशन फॉर बैकवर्ड क्लासेस एक्ट को रिपील कर दिया, डिलीट कर दिया और कॉन्स्टिट्यूशन में ऐड कर दिया. सो नेशनल कमीशन फॉर बैकवर्ड क्लासेस इज एक्चुअली अ constitutional body. It is not a statutory body because the same body has been given constitutional status at par with SC/ST and SC/ST commission, OBC commission. So all of the three are now constitutional bodies. अब 50% has been breached now. by 103rd constitutional amendment, 10% for to EWS, so 50%. ब्रीच हुआ कि नहीं हुआ? अभी हो गया. नाउ 10% फॉर पुअरर, जो सुप्रीम कोर्ट ने अनकॉन्स्टिट्यूशनल कहा था उसको, इट हैज नाउ बीन मेड EWS. Now no creamy layer for SC ST, it is still there. There is a case, we'll see that. No reservation in promotion. सुप्रीम कोर्ट ने कहा रिजर्वेशन इन प्रमोशन नहीं होगा. इसको ओवरटर्न करने के लिए 77th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, जो आर्टिकल 16(4)A मैंने आपको दिखाया, which we left, कि there will be reservation in promotion for SC and ST, not for OBC. So most of the provisions actually are some or the other way they are subverted. You are getting my point? So Supreme Court ने कहा नहीं, रिजर्वेशन में प्रमोशन नहीं होगा, प्रमोशन में रिजर्वेशन नहीं होगा, इनिशियल ज्वाइनिंग स्टेज पर होगा. So it will only be there in joining state, but it will not be there in promotion. You are getting my point? So this Supreme Court, लेकिन SC ST reservation provide करने के लिए a provision was added by 77th constitutional amendment. So Supreme Court judgment को overturn कर दिया. 103rd constitutional amendment overturned the 10% EWS and 50% ceiling. This 77th amendment provided for reservation in promotion also. So वो भी जो है वो भी overturn कर दिया. Although this has been held valid in M Nagaraj case. And what you call other case also, we'll discuss one or two questions. अब इसमें ये देखिए, now one more thing. For example 2017 में 100 vacancies आती हैं. So in 2017 there is 100 vacancy. 100 में general का, okay, so general would be before EWS, general would be 50.5, SC 15, ST 7.5, OBC 27. ओके, ये होगा 100 का ब्रैकेट, यही होगा ना. बिफोर EWS दिस वुड बी द ब्रैकेट. कोई डाउट है इसमें? अब फॉर एग्जांपल 15 SC सीट्स, thousands and thousands of such seats are vacant, not in UPSC but in other exams. Why? Because you don't, minimum marks जो qualifying है, many times people don't score. So thousands of such seats are vacant. For example, 5 seats remain vacant in 2017. So next year there would be how many seats? 105. So 50% of 105 would be 52.553. So actually 2 seats of SC, 50% से ज्यादा reservation नहीं हो सकता है. 2 seats of SC next year is transferred to general, because ये 5 seat तो अलग है. These 5 seats are separate. These are of SC seats which are vacant of last year. इसी पे कॉन्स्टिट्यूशन अमेंडमेंट आया कि नेक्स्ट ईयर सीट्स में जो प्रीवियस ईयर्स की बची हुई सीट है जिस कैटेगरी की, उसी में काउंट होगी. सो इट विल ब्रीच 50%, नो प्रॉब्लम, बट वॉट एवर इज द फ्रेश नोटिफिकेशन उसमें 50% होगा. लेकिन जो पहले की सीट्स बची हुई है जिस कैटेगरी की, वो उसी कैटेगरी को. सो द सीट्स दैट आर लेफ्ट ऑफ अ पर्टिकुलर कैटेगरी, दे विल बी. You are getting my point now? So again a constitutional amendment was made, okay, that 50% ceiling would be breached. Okay, so again I am repeating everything. Okay, आराम से. First there is a permanent commission under which article? 338B, वो national OBC commission. ये permanent है, इसका general काम है. No permanent general work. Look into the safeguard for backward classes, look into the complaints of discrimination, any policies and programs related to OBC. This is a permanent constitutional body. This was a statutory body by an ordinary law. Since the party promised in its manifesto that if we come to power, we will give constitutional status to OBC commission. So OBC Act, National Commission for Backward Classes Act को खत्म कर दिया, deleted, repealed, and the same has been given a constitutional status by 102nd Constitutional Amendment Act. So there is great amount of confusion between Backward Classes Commission under 340 and Backward Classes Commission under 338B. 338B is a permanent body which is a constitutional body and with everything that is given in the constitution. और उनका काम क्या है? General and inclusion, over inclusion, under inclusion of OBC, all these things. Now you have 340. 340 is a temporary body which is created time to time. How many times it has been created till days? 3 times. First was in 1953, Kaka Kelkar Commission. Second was in 79, Mandal Commission. And third is Justice G. Rohini Commission, जो अभी काम कर रहा है। 12th टाइम 1 फरवरी को एक्सटेंशन दिया गया है। 12th टाइम इट हैज बीन गिवन एक्सटेंशन बिकॉज इट इज अ वेरी कॉम्प्लिकेटेड थिंग। कैसे आप ओबीसी को क्लासिफाई कर देंगे 2 साल में? You see the magnitude of Indian social democracy, demography and population and caste demography, it is impossible. So the Justice, Honorable Justice G. Rohini, along with other members of the commission, is working very hard, and initially it is said that they are going to declassify within a year or two OBCs ki 5%, 18% and 18 of 5, 23 and 4 or 9%, 18% and what you call jo bhi bach gaya, okay, so that will be given. Any such classification 18, 8, 26 and then what you call 1, so any such classification they will do, or 12, 8, 7 aise karenge. Within OBC also there will be classification. Now first commission was Kaka Kelkar commission. This was constituted under which article? 340 by whom? President. It is not of much significance. Second commission is Mandal commission. Mandal commission was constituted on 1st January 1979. मन लगाकर काम किया, 1980 में सबमिटेड इट्स रिपोर्ट बाय द टाइम गवर्नमेंट चेंज. सो मंडल कमीशंस रिकमेंडेशन वर केप्ट इन द बैक बर्नर फॉर 10 years. When National Front government came to power in 1990, they implemented the Mandal Commission recommendation कि चलो 27% reservation would be given to OBCs in central and state government jobs. After this announcement, the National Front government also lost majority and Congress came to power. They said chalo 15, 7.5, 27, 10 sub, so 10% for poorer among general, unko bhi de diya. All these 27%, 10% was clubbed and challenged in Indira Sahni versus Union of India, jahan Supreme Court ne kaha 27% reservation to OBC is constitutionally valid, but only the non-creamy layer among the OBCs will get, creamy layer will not get. Second, constitute a permanent commission देखने के लिए, constitute a to under inclusion and over inclusion. So Parliament enacted National Commission for Backward Classes Act or 1993. This has been repealed और अभी उसी commission को they have given permanent constitutional status. Third, there will be no creamy layer for SC ST because the basis of reservation is untouchability and relative isolation from the other parts. So that is why there will be no creamy layer in SC ST. Next, there will be no reservation in promotion. Reservation only will be at joining stage. Again, this provision has been overturned by Parliament by 77th. 10% reservation for poorer section is unconstitutional because there is no provision in the constitution for economically weaker sections. So rather than giving them reservation, government actually got a bill passed and amended the constitution and added a new provision up to 10% reservation for economically weaker section, which is yet with challenge and the petition is pending in Supreme Court. You are getting my point. So all these provisions related to that economically weaker section and all these things, and what you call isse related, you see 50% ceiling will be breached if the seat is of last year. This year if 5 seats of a particular category is left, next year it will be counted only in that category, it will not be counted in 50% or translated to general category. Getting my point? So this is all which is done. Now we have to focus on third backward classes commission. Let's wait for the report, and what they will not ask you that tough. They just want you to know the difference between article 340 and 338B. That is a permanent backward classes commission, and that commission which is constituted time to time. Okay, now you were asking a question. Puchiye. Creamy layer and non-creamy layer is determined on the recommendation of what you call Ram Nandan Prasad Committee. I think 8 August 1993. They came up with a notification by DOPT कि कुछ criteria अब आपको जानना नहीं है, मैं बताऊंगा भी नहीं क्योंकि कोई फायदा नहीं है. Okay, but just you understand कि if your parents are both in group B, then you will not get. If one of the parent is group A and what you call got group A after 40 years, then you can get. So certain classes of employment are actually excluded. कि और annual income 8 lakh अभी उसको बढ़ा दिया. You have getting my point. So what is the present limit? 8 lakh they are contemplating to make it like 12 lakh or something. And but they do not उसमें salary and agricultural income is not counted. Okay. So any other source. Okay. That's a don't go into that. You just need to know that there is a creamy layer within OBC. Those who are relatively well off, they will be removed, and those who are relatively non-creamy, they will be adjusted. That is the creamy layer. Okay, so this is entire, and now we will see after this. अभी तो लिखवाना जरूरी हो गया है. After this, we'll see reservation in private sector. Okay, so you first, you please write. मैं लास्ट में जो बैठे हुए समझ में आ रहा है आप लोगों को? हाँ, अब तो मैं जा नहीं सकता हूं. यस को ही भरोसा करना पड़ेगा. गॉस्पेल ट्रूथ. हाँ, आर्टिकल 16. हाँ, पूछिए. हाँ, so because by a constitutional amendment, so nothing can be done. हाँ, 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 तो ये तो पार्लियामेंट है ना. So of course you are, whatever you are saying is from one perspective, but this is what, who will decide? Supreme Court will decide. Parliament has done its job. Now the case is pending in Supreme Court. Okay. Of course, reservation is a sensitive thing. Okay. So that we must keep in mind. हाँ, पूछिए. कौन सी सीटें? हाँ, वो जनरल में नहीं काउंट होगी, इसीलिए तो कॉन्स्टिट्यूशनल अमेंडमेंट आया. दे विल नॉट बी क्लब्ड इन जनरल. दे विल बी वॉट एवर कैटेगरी दे हैव बीन लिफ्टेड ऑफ लास्ट ईयर, वो उसी में होंगी. सो एक्यूमुलेट करेंगी ओवर द इयर्स, दे विल एक्यूमुलेट, बट रिक्रूटमेंट विल बी डन ओनली फ्रॉम दैट कैटेगरी. इट इज इनजस्टिस ना. This year's 5 categories seat A and you are giving it to another category, so it belongs to last year. You couldn't find candidate, you will find. So it has accumulated, actually hundreds of such seats are there. हाँ, वो सीट तो पिछले साल चली ही गई थी. अब दूसरे की दौलत पे लालच. हाँ, हाँ, हाँ. So those seats were already gone last year. It's only because you couldn't find suitable candidates, so those seats are carried forward. It is called carry forward rule. So those seats are carried forward, but they will be counted as a separate class. They will not be counted in notification for that year. समझ में आ रही है ना बात? So please write Article 16. Article 16 deals with public employment. Full stop. There shall be equality of opportunity in matters of public employment. Full stop. आगे लिखिए. No citizen shall be discriminated on grounds of, please write, no citizen shall be discriminated on grounds of, ये ground लिखिए सारा. Please write which all grounds. On grounds of religion, race, caste, sex, descent, and place of birth and place of residence. Next you write, Parliament can prescribe residence as a criteria. Parliament can prescribe residence as a criteria for certain classes of employment. Parliament can prescribe residence as a criteria for certain classes of employment within the state or union territory. Parliament can prescribe residence as a criteria for certain classes of employment within the state or union territory. Next, you write, the state can also make any provision for reservation of appointments or posts. State can make any provision for reservation of appointment or post State can make any special provision for reservation of appointment or post in favor of any backward classes of citizens okay, which are not adequately represented in the eyes of the state. Which are not adequately represented in the eyes of the state. Which was not adequately represented in the eyes of the state. Okay, next you write the 77th constitutional amendment also provided for 77th constitutional amendment also provided for 77th constitutional amendment also provided for reservation in promotion for scheduled caste and scheduled tribe. Reservation in promotion for scheduled caste and scheduled tribe. Okay, then you write the state can make any law providing for incumbent of an office ठीक है, with respect to affairs of religion or denomination, incumbent of an office with respect to affairs of religion or denomination, incumbent of an office with respect to affairs of religion or denomination, okay, incumbent of an office with respect to affairs of religion or denomination, okay, comma, a person being appointed there professing a particular religion professing a particular religion okay, so you are getting this. ठीक है, अब आगे लिखिए. हाँ, if I'm giving you an example, state can make any such law. There is no prohibition, they have not made now, but there are many laws passed by the state legislature where actually what they have done, they have reserved a particular temple. हाँ, temple में appoint state करेगा पर only हिंदू को. हाँ, But then this, otherwise it will be a discrimination under Article 16, na? It is a public employment. So the provision has been added. अब बस इतना याद रखना है. Next you write Article 338B, Article 338B, capital letters B. Article 338B, capital letters B, provides for Permanent National Commission for Backward Classes. Article 338B provides for Permanent National Commission for Backward Classes. Permanent National Commission for Backward Classes. Okay? Permanent National Commission for Backward Classes. आगे लिखिए the 102nd Constitutional Amendment. ये लिख दिया, ऐड नहीं किया ना ये. The 102nd Constitutional Amendment added this provision. Okay? 102nd, क्योंकि कभी कभी they ask which constitutional amendment created Article 338 capital letters B, that is National Commission for Backward Classes. This again we will see in constitutional bodies, SC Commission, ST Commission and backward. Why it is a constitutional body? Because it is mentioned in the Constitution. अब नीचे आइए. Article 340 provides for the President Article 340 provides for the President to constitute Article 340 provides for the President to constitute such commission to investigate into the conditions of socially and educationally backward classes of citizens. To investigate into the conditions of socially and educationally backward classes. To investigate into the conditions of socially and educationally backward classes. And give recommendations thereupon. And give recommendations thereupon. And give recommendations thereupon. Okay? Next you write, please. The commissions have been constituted time to time. The commissions have been constituted time to time. The commissions have been constituted time to time. Okay? First Backward Classes Commission, write A for apple. First Backward Classes Commission. Kaka Kelkar Commission. Okay. Second चूंकि voluminous है, so you write third here. First Backward Classes Commission, Kaka Kelkar Commission. Right, next third Backward Classes Commission. Okay, third Backward Classes Commission. First के बाद सीधा third लिखिए. Third Backward Classes Commission. Justice G. Rohini Commission. Justice G. Rohini Commission. For sub-categorization of OBCs. Justice G. Rohini Commission. For sub-categorization of OBCs. Justice G. Rohini Commission for sub-categorization of OBCs. Okay? So this is done. सब कैटेगराइजेशन ऑफ ओबीसीज. नाउ द पॉइंट इज कि ब्रैकेट में लिख दीजिए येट टू सबमिट रिपोर्ट मार्च 2021-22. Yet to submit report March 2022. Maybe you will be reading these notes later. So if you prepare for exam. So, yet to submit report March 2022. Whoever, when you will be starting your preparation, you may read later. Okay. Next page you come. I'm not saying 2032, but in 22 only after few months. Okay. So सब क्या हुआ, कुछ छूट गया? सब कैटेगराइजेशन ऑफ, वो भी समझ रहे हैं ना? फर्स्ट बैकवर्ड क्लासेस कमीशन काका केलकर कमीशन, थर्ड बैकवर्ड क्लासेस कमीशन. एंड व्हाट इज द डिफरेंस बिटवीन 340 एंड 338B? 338B इज अ जनरल कमीशन, परमानेंट बॉडी. 340 टाइम टू टाइम बनता है विथ अ पर्टिकुलर मैंडेट, विथ अ पर्टिकुलर इशू, विथ अ पर्टिकुलर TOR, टर्म्स ऑफ रेफरेंस. उनको एक काम दिया जाता है, यू हैव टू डू दिस पर्टिकुलर वर्क. ओके, नाउ यू राइट सेकंड बैकवर्ड क्लासेस कमीशन, जस्ट ये बीपी मंडल कमीशन, सेकंड बैकवर्ड क्लासेस कमीशन, बीपी मंडल कमीशन. Second backward classes commission, BP Mandal Commission. Please write, it was constituted in 1979. By the President under, it was constituted in 1979 by the President under Article 340. Okay. Now you write major terms of reference. Major terms of reference. Major terms of reference. Okay. A. To determine criteria for defining socially and educationally backward classes. To determine criteria for defining socially and educationally backward classes. Determine criteria for defining socially and educationally backward classes. B. Steps for their advancement. Steps for their advancement. C. Desirability of reservation. Steps for their advancement. C. Desirability of reservation. Okay. B है steps for their advancement. C. Desirability of reservation. Desirability समझते हैं ना? So desirability of reservation. This was the term of reference of third backward classes commission or second? Second. Who gave these terms of reference? BP Mandal gave to himself. तो किसने दिया? Who gave this work to do? हाँ तो इसमें बीपी मंडल, इंटेस्टाइन ने खाना खाया. अरे आपने खाया, इंटेस्टाइन में खाना गया. So you are getting this point. So who constituted the commission? President. What was the terms of reference given there? Who was to follow these terms of reference? BP Mandal. Who was to implement it? Government. लिखिए आगे. VP Singh government in August 1990. VP Singh. V space P space Singh. VP Singh नाम नहीं सुने हैं? V space P space विश्वनाथ प्रताप Singh. Okay. So V space P space सिंह, स्पेस कोई नहीं लिखेगा भाई। वीपी सिंह गवर्नमेंट इन अगस्त 1990, VP Singh government in August 1990 implemented the recommendations. VP Singh government in 1990 implemented the recommendations. Right, major recommendations. VP Singh government in 1990 implemented the recommendations. अब लिखिए मेजर रिकमेंडेशंस। ए, पहले तो कोट जो दिखाए थे कोट लिखिए। ये कोट मतलब रिकमेंडेशंस क्या, लिख लीजिए कोई बात नहीं। देयर इज इक्वालिटी ओनली अमंग इक्वल्स, देयर इज इक्वालिटी ओनली अमंग इक्वल्स, there is equality only among equals. To equate unequals is to perpetuate inequality. There is equality only among equals. ठीक है, हाँ एकदम कॉमा देना है। There is equality only among equals, कॉमा। To equate unequals is to perpetuate, perpetuate मतलब बढ़ा देना, ठीक है। टू इक्वेट अनइक्वल्स इज टू परपेचुएट, TUATE, टू इक्वेट अनइक्वल्स इज टू परपेचुएट इनइक्वालिटी। क्या कह रहे हैं, बोलते हैं देयर इज इक्वालिटी ओनली अमंग इक्वल्स, जो इक्वल है उन्हीं को इक्वली ट्रीट कीजिए। अनइक्वल्स और इक्वल को एक जैसा ट्रीट कीजिए। इफ यू विल बी ट्रीटिंग अनइक्वल्स अलाई, एक्चुअली यू आर प्रोमोटिंग इन इक्वालिटी। There is equality only among equals. To equate equals and unequals, मतलब unequal और equal को एक जैसा ट्रीट करेंगे, so you are perpetuating, you are increasing, promoting, aiding inequality. So this was the next. You write 52% of the population comprises other backward classes. 52% of the population comprises other backward classes. 52% of the population comprises other backward classes, and 27% reservation can be granted to them. 27% reservation can be granted to them. Okay, now you write, just put an asterisk and write, after the 27% reservation, I told you ना इसमें 2 घंटे लगेंगे। after the 27% reservation by VP Singh government, after the 27% reservation by VP Singh government for whom? OBCs, comma, additional 10% was granted after 27% reservation by VP Singh government for OBCs. Okay, 27% reservation by VP Singh government for OBCs, additional 10% to the poorer sections, additional 10% to the poorer sections among, सिर्फ एक सबसे प्यारा टर्म होता है unreserved. This is the only term that should be precisely used. Among unreserved communities, okay, was granted. ठीक है, among 10% reservation among the poorer sections of unreserved communities was granted. Okay, यानी पहले वीपी सिंह गवर्नमेंट ने दिया 27%, नरसिम्हा राव गवर्नमेंट ने दिया 10 more percent they gave, so it became 27 plus 10, 37, and 15 for SC and 7.5 for ST was already there. So this happened. Now you write the OBC and poorer sections reservation, the OBC and poorer sections reservation was challenged in OBC and poorer sections reservation was challenged in Indira Sahni versus Union of India. Was challenged in Indira Sahni versus Union of India. ठीक है? So now you write Indira Sahni versus Union of India. केस लिखेंगे ना, क्या केस में क्या हुआ? इंदिरा सोनी वर्सेस यूनियन ऑफ इंडिया. बताइए व्हाट इज द इशू. नाउ यू विल राइट द केस एज अ टॉपिक, इंदिरा सोनी वर्सेस यूनियन ऑफ इंडिया. ज्यादा लिखाने के लिए थोड़ा जल्दी करना पड़ेगा, अदरवाइज स्किप करना होता है. सो इंदिरा सोनी वर्सेस यूनियन ऑफ इंडिया, ईयर 1992, राइट इन ब्रैकेट 1992. A 27% reservation for OBCs, was held constitutionally valid. 27% reservation for OBCs was held constitutionally valid. Was held constitutionally valid. 27% reservation for OBCs was held constitutionally valid. Next. This shall be availed by non-creamy layer among this shall be availed by non-creamy layer among OBCs. ठीक है. नेक्स्ट, अ सी पॉइंट, नेक्स्ट पॉइंट, अ परमानेंट कमीशन, this shall be availed by non-creamy layer among OBCs. Next point, a permanent commission to be set up to look into over and under inclusion. Over and under inclusion. Okay, full stop, bracket. Acha, ये now what we will do, whatever is the judgment of Supreme Court, what happened after उसी में लिख देंगे. So bracket में लिखिए, so National Commission for Backward Classes was constituted. So National Commission for Backward Classes was constituted. So National Commission for Backward Classes was constituted, which became constitutional body later. You have already written. So National Commission for Backward Classes was constituted, which became constitutional body later. So National Commission for Backward Classes was constituted, which became constitutional body later. What is the difference between previous body and this body? Previous was an ordinary law. Ordinary law is made by simple majority. अभी बना दिया constitutional body, और constitutional body बनने का मतलब क्या है? Now it is a constitutional body, so any change will be done by special majority. So the sanctity of body has increased or decreased? बहुत ज्यादा sanctity high हो गई. Now it is in constitution. Statutory body को खत्म कर दिया. Now it is a constitutional body. Okay, you are getting that point. Okay, so now National Commission for Backward Classes, which article? हाँ, 340. एक भी आदमी 340, 338 B for Bombay. 338 is National Commission for Scheduled Caste, 338A is Scheduled Tribe, and 338B is Backward Classes Commission. So these three are constitutional bodies. Okay, and 340 is time to time constituted for a specific पर्पस, उसको भी कहते हैं बैकवर्ड क्लासेस कमीशन, बट यू मस्ट नॉट गेट कंफ्यूज बिटवीन द टू. अभी जो थर्ड बैकवर्ड क्लासेस कमीशन बना है, क्या नाम है उसका? जी, इज इट लुकिंग इनटू द सब कैटेगराइजेशन ऑफ ओबीसीज? इट इज स्टिल वर्किंग. ओके, तो ये पॉइंट हुआ. नेक्स्ट पॉइंट यू राइट, नो रिजर्वेशन इन प्रमोशन. नो रिजर्वेशन इन प्रमोशन. नो रिजर्वेशन इन प्रमोशन. ब्रैकेट में लिखिए, क्या लिखना चाहिए? 77th कॉन्स्टिट्यूशनल अमेंडमेंट no reservation in promotion. 77th constitutional amendment provided for SC/ST reservation in promotion. 77th constitutional amendment provided for SC/ST reservation in promotion. Okay, next point. Okay, ये हो गया. Next point, 10% reservation to poorer sections. 10% reservation to poorer sections was declared unconstitutional. 10% reservation for poorer sections was declared unconstitutional. ठीक है. अब इसमें भी क्या हुआ? 103rd constitutional amendment, write in bracket, 103rd constitutional amendment provided for up to 10% reservation for 103rd constitutional amendment provided for up to 10% reservation for economically weaker sections. Economically weaker sections. Okay, so most of the provisions 50%. Next you write 50% must be the limit of reservation. अब इसमें सुनी लीजिए, इसमें ओनली वर्टिकल रिजर्वेशन का है. कास्ट बेस्ड रिजर्वेशन कैन नॉट ब्रीच 50%. अदर रिजर्वेशन फॉर वॉर विडोज, differently abled, any reservation which cuts across the communities. So war widows, all the community. Differently abled, all the community. Getting any reservation which cuts across the communities is called horizontal reservation. And cost based reservation are vertical. So some of you may ask later, horizontal, any, so a differently able can be from any community. War widow can be from any community. These reservations which cut across communities are called as horizontal reservations, while caste based reservations are termed as vertical reservation. Ye actually just a definition. This is not in the constitution or law. This is just, you may read an article where they will write vertical reservation, horizontal, so you must understand कि ये कहना चाह रहे हैं. ठीक है. So this is the entire nomenclature. So in public employment, can there be reservation on the basis of residence? नहीं. Time and again Supreme Court has declared these reservations as unconstitutional. Abhi we will deal with a topic after the break. You just write the topic reservation in private sector. I told you na article 16 2 घंटे हो गए. Only article 16. Because if we do one article in every day, so it will be 32 classes for fundamental rights and 2 light years for polity. But this is necessary कि आपको question आ सकता है. Okay, so reservation in private sector. So we'll take a 10 minutes break. We come back, we'll do reservation in private sector. इस साल का burning issue है, चल रहा था नीचे करोल बाग में. Welcome back students, please settle down. So we will continue the discussion. Now reservation in private sector. Okay. Now this is something which has become a new, can there be a reservation in public sector on grounds of residence? No, there have been attempts by Andhra Pradesh, Rajasthan. Every time such an attempt has been declared as unconstitutional. So any such reservation is blatantly unconstitutional. Meanwhile also there was an attempt, all the constitutional scholars, Subhash Kashyap, Fali S. Nariman, Faizan Mustafa, All the constitutional scholars are unanimous that there cannot be a reservation in public sector on grounds of residence. Certain reservations have been allowed in what you call in different categories in horizontal, okay. But generally what you need to know is there cannot be a reservation in public sector on grounds of residence. Now in private sector. Now this is a new area. Why? Because in private sector it not be challenged under Article 16. It will be challenged under Article 19(1)(g). Everyone has a fundamental right to practice any trade, occupation, profession. State legislative assembly by passing a law reserving 75% seats for those salary where 30,000 or less, okay, will be reserved for local youths. So this will be my fundamental right to practice any trade, occupation, profession is violated. Why? When the state legislative assembly passes a law and on grounds of residence directs the private sector to reserve 75% seats of those salary which is 30,000 or less. Yani, matlab not on a very higher level, so will be from locals. Okay. This law was challenged in Punjab and Haryana High Court, where the Punjab and Haryana High Court stayed the law. And since the hearing was there only for 50 seconds, it started and High Court said that we stay the law. So then Haryana went to Supreme Court as violation of principle of natural justice that we were not given enough opportunity to present our views. Supreme Court did not say that this is right or wrong. Supreme Court stayed the judgment of Punjab and Haryana High Court and asked Punjab and Haryana High Court to go through the verdict once more and 1 month time mein phir se suniye, hear to all the parties and give a judgment. So Supreme Court categorically says that we are not going into the merit of the law. We are only saying that since Haryana was not given an enough opportunity to present its case in Punjab and Haryana High Court, so we direct the Punjab and Haryana High Court to listen to the case again and within 1 month declare that whether it is constitutionally valid or not. Again, then it will be challenged in Supreme Court. So private sector has been a matter of contention because Article 16 prohibits discrimination only in public employment. So keeping the loophole of the law, they are making laws and violating Article 19(1)(g) and 14. Now to what extent this can be a reasonable classification? This is also scholars, I have been extensively reading on this, scholars say this is against the economic integration of India. If private sector is giving jobs only to, then how will the people, why will people travel? So it is also, economic integration is also important. GST, economic integration. All the indirect laws have been subsumed other than 5. Aviation, turbine fuel, liquor for human consumption. Motor spirit, I don't take obviously, but I'm just telling. So aviation, whoever takes, I don't judge them, but of course. So aviation, turbine fuel, liquor for human consumption, and motor spirit, commonly known as petrol, diesel and natural gas. These are the 5 things which I've kept outside the ambit of GST. Okay, outside the ambit of GST, all other indirect taxes have been subsumed. So it is a classic case of economic integration. So many provisions in the constitution, interstate trade and commerce should be free. Article 301, Article 280, federal fiscal federalism, Article 279A, GST Council, Article 269A, interstate goods and services exchange, Article 269, consignment of goods, so all these provisions of the constitution promote economic integration of the country and one nation, one market. Okay, this entire provision of only allowing locals is detrimental to that provision. It is a bit naive and premature to make a comment on that when Punjab and Haryana High Court is actually hearing a petition on this. Okay, so which article it is challenged? Not under 16, under 19(1)(g), right to practice any trade, occupation, profession is being hindered by the state. She is such a smart girl. Huh? They all came at 3:30. She came at 5:10. Getting my point. In UPSC, when they introduced Indian Forest Service prelims along with civil service examination, so first 2 years what happened, there was CSAT. So anybody who is preparing for forest prepares for forest and geology, matlab agriculture, forest related subjects. Not necessarily they are good at CSAT. At that time there was CSAT. So somebody, average IITians, IIMs and all CATians, they scored 189.90 out of 200, 180 out of 200. It was a halwa paper, CSAT paper 2. They got 180 and the cutoff went 241 for GS and CSAT, matlab civil service examination. For forest it was 266. 266 was the cutoff in the year 2013. So 99% of people who were preparing for forest, they were eliminated. Because they were preparing for forest, they couldn't get 190 in CSAT. Okay, all those IIMs, CATians and IITians, they actually scored 180 and 60 over there, so they made it to. So, and out of 700 people were invited to write, 1000 people were invited to write mains. 700 filled DAF because they just ticked forest B or CSE. So they were not serious. They thought we'll be taking CSE. Why will we take forest? 700 filled DAF, 500 went to write mains only. Out of 500, few dropped after the first few papers. And 300 were invited for interview, 85 were selected. So it was that opportunity. That year, actually, somebody I knew got selected that year only. So the point is, ki it was a golden sort of opportunity. Now the CSAT forest, यहाँ 92 cut off जा रहा है, और 120 लाने में तो literally it is like forest prelims is very relatively, and actually you should target forest. You should target forest prelims. Then you will. This is 92, so this would be like very easy. If you target that I have to qualify forest at any cost, all the time you will be thinking of that, then this will, क्योंकि forest और इसका exam एक साथ होता है, ये तो मालूम है ना, prelims एक साथ होता है, mains चूंकि उसका agriculture, geology, forestry, all these subjects are there. So you are getting my point. So this is something which is very important. Okay, so let's come to this. So this is what you call this reservation in private sector. So please write reservation in private sector. Reservation in private sector. Please write the provisions of Article 16 prima facie, मतलब on the face of it, पहली नजर में, prima facie deal with public employment. Deal with public employment and Article 19(1)(g), Article 19(1)(g) provides for fundamental right to, Article 19(1)(g) provides for fundamental right to trade, occupation and fundamental right to trade, occupation and profession. Fundamental right to trade, occupation and profession. Full stop. The Haryana State Legislative Assembly, passed Haryana State Employment of Local Candidates, passed Haryana State Employment of Local Candidates, passed Haryana State Employment of Local Candidates Act reserving 75% of those positions in private sector reserving 75% of those positions in private sector with a salary up to 30,000, reserving 75% of those provisions in private sector with a salary up to 30,000 for the local youths. Full stop. Just for the local, just write, put an asterisk and write, the law is pending before Punjab and Haryana High Court, pending before Punjab and Haryana High Court. Okay, to be judicially रिव्यूड. बोलिए, जोर से बोलिए, गलत बोलिए और अच्छा है, सीखिएगा कैसे, जो आ रहा है सब बोलिए, ठीक है. देयर शुड बी नो इनहिबिशन. जिसने की शर्म उसके फूटे करम. So this actually we went on a when we in our college when we passed out, final year was invited by one ma'am. She invited for lunch. So there was a friend of mine who ate like anything. So he said कि जिसने की शर्म उसके फूटे करे. He is now in lieutenant, I think, in army. उसी वक्त बन गया था, अभी तो ऊपर चला गया होगा. Anyways, so मतलब ऊपर चला गया. अरे यार कसम से. I mean, this is really, how can you like laugh also? I literally meant to say कि मतलब lieutenant is the first point and he must have gone to because major general command. Huh? Then why you are laughing? Huh? जी? नहीं, I obviously यार we cannot, मतलब even anybody who see entire UPSC, Vision IAS, okay, India Gate, everything is secured. Freedom of speech and expression, me teaching here, you sitting here, UPSC notification, only because there is an army that is securing the national frontiers of India. That is the prime mandate of the state. Or I never even thought, but aap log, you all are, so it is like, so actually I said ki now they have prohibited na Facebook and all army officers cannot. So I don't know, after many years I am not in touch. So he joined as a lieutenant, they go up to major general. So abhi to wo to bahut hi major general to बूढ़े लोग ज़्यादातर, मतलब ज़्यादा senior people, but yes. So obviously armed forces, we cannot understand. There is a friend of mine, he is in West Bengal cadre. He said ki in his village, somebody who died in 80s, late 80s, his body was brought in some 15-20 years back in avalanche in Siachen glacier. So can you imagine such a situation? Like the body was brought after 20 years, minus 48 degree. So this is the supreme sacrifice. With obviously these days WhatsApp universities can call anything, but this is the highest form of sacrifice that is given. And there is not what you call the remuneration or benefits are not very high, you say. So of course it is the zeal to work for the country that is there. Okay. So there we come back to कि जिसने की शर्म उसके फूटे करम. So the point is कि क्या लिखा आपने last? हाँ? Judicially reviewed. Next point you write the pros and cons of such legislation are as follows. A. Against the economic integration of the country. Okay. B. Promotes regionalism and against national unity. Promotes regionalism and against national unity. Promotes regionalism and against the national unity. So, B. C. What is C? It promotes local interest over national interest. It promotes local interest over national interest. It promotes local interest over national interest. Okay, next, it will lead to flight of capital and investment. Flight of capital समझते हैं, पैसा उड़ जाना, यानी इन्वेस्टमेंट, इन्वेस्टर भागेगा कि आएगा? भागेगा, वो क्यों लोकल को एम्प्लॉय करेगा? इट विल लीड टू फ्लाइट ऑफ कैपिटल एंड, लास्ट मोमेंट पे करेंगे. So it will lead to flight of capital and investment. Next you write, this will give rise to similar tendencies in other states. Similar tendencies in other states. Positive इसका सिर्फ एक ही है, locals would get jobs. Okay, so locals would get better and other states would learn कि if our youths are not getting job in Haryana, so we have to create situation. Okay, so you can write this. It may lead to better job prospect for local youths and inspiration for other states. It may lead to better job prospects for other states, for local youth, sorry, it may lead to better job prospects for local youths and will force other states to look into what? Look into employment generation. Look into employment generation. ठीक है? Look into employment generation. हो गया? So this is what you call Article 16. Now we have Article 17. ठीक है? We have Article 17, which is small, easy one. It says untouchability is abolished and its practice in any form is forbidden. Enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. So first question that has been asked 2000 times, that the term untouchability has not been defined in the constitution. This is a very significant statement. Why? Because Justice D.Y. Chandrachud in Sabrimala verdict, in one of the paragraphs says that the prohibition of women into Sabrimala temple complex is violation of Article 17. So although this view was not taken by the majority judgment, but this is also one of the views that discriminating women in the menstruating age group is actually practicing untouchability. That is Justice D.Y. Chandrachud says. इसीलिए कह रहा है untouchability has not been defined and it has wider ramifications. The Constituent Assembly deliberately left, it is not only SC/ST discrimination or scheduled caste discrimination or any such discrimination, it is also expanded form of any form of discrimination, untouchability, social economic boycott and all these things. So first question is, the term untouchability has not been defined in the constitution. Next is, and its practice is forbidden. This is one such fundamental right which is absolute in nature. मतलब इसमें no ifs and no buts. This is Article 17 is absolute in nature. Any form of untouchability is abolished and its practice in any form is forbidden. Next, what is the punishment? Who will prescribe the punishment? Parliament. And Parliament has enacted SC/ST Prevention of Atrocities Act 1989 and Protection of Civil Rights Act 1955. Protection of Civil Rights Act deals with anybody who practices untouchability towards any member community. Main act is SC/ST Prevention of Atrocities Act 1989. अब आते हैं recent amendment पे. So 3 years back there was big controversy. SC/ST Prevention of Atrocities Act 1989, in one of the judgments, Subhash Kashinath Mahajan case, the Supreme Court ruled 3 things. 1, before registration of FIR under SC/ST Act, there will be a preliminary inquiry by DSP rank officer. So if anybody goes with the complaint, there will be a preliminary inquiry by DSP rank officer that whether the case is fit to register an FIR or not. Second, before arrest, the SSP shall give permission, then only they will be arrest. So you know the difference between cognizable, non-cognizable offense, bailable, non-bailable offense, compoundable, non-compoundable offense. Huh? What? See, bailable offenses are those offenses where bail is a right. मतलब फॉर एग्जाम्पल ऐसे लग गया किसी को, कुछ छोटा सा क्राइम किया आपने, ज्यादा बड़ा, सो इट इज अ बेलेबल ऑफेंस. द मोमेंट यू प्रेजेंट योर सेल्फ इन द कोर्ट, इट इज नॉट द डिस्क्रिशन ऑफ कोर्ट. कोर्ट हैज टू give you bail. Non-bailable offense means it doesn't mean that you will not get bail. Non-bailable are those offenses where the discretion of court is there whether the bail will be given or not. 99.9% of the cases, lower court does not, because their credibility is in stakes, they will not give, go to high court. Okay, so non-bailable doesn't mean you will not get bail. It is related to bailable, where you have a right to bail. In non-bailable, it is the discretion of the court to give bail or not to give. Compoundable offenses are those offenses normally civil in nature where a compromise can be reached. Non-compoundable, आपने किसी का murder कर दिया, the family members forgave you, then also you will be facing the heat. That is because the case will be registered XYZ versus state of UP. So who is the party? State, and it is a criminal wrong which is against the society at large. So compoundable offenses are those offenses where you cannot arrive at a compromise. Compromise नहीं हो सकता है, आपको सजा ही मिलेगी. This is not Saudi Arabia where in UAE if you murder there is khun baha. You can give some money and family members, if they forgive without any pressure or undue influence, they can forgive. Go ahead and forgive and you will be saved. And this happened also. Family members are forgiving. Actually, there was a case where Indian youths from Punjab, they had a brawl, fight or argument at a dhaba in UAE and they murdered someone. So वहां तो सीधा सबको फांसी. So Sushma Swaraj ji was Minister for External Affairs. So the family agreed. So some amount was to be given as khun baha. So it was collected. She was actively instrumental, collected the amount, it was given, and all of them came back. Okay. So it is compoundable are those offenses where a compromise cannot be reached. Now last is what? क्या बचा? Bailable, non-bailable, compoundable, non-compoundable, and cognizable, non-cognizable. Cognizable offenses are those offenses where the investigating officer does not require a warrant from the court. She or he can go ahead and arrest you. While non-cognizable offenses are those where the investigating officer requires a warrant. So bailable are those where bail is a right. Non-bailable is those where discretion of the court. Compoundable offenses, a compromise can be reached. Non-compoundable offenses, a compromise cannot be reached. Cognizable offenses where the investigating officer does not require a warrant. In non-cognizable officer, he requires a warrant from the civil code. So example, what you call protection of rights, protection of Muslim women rights on Marriage Act 2019. Makes, if there is a instant triple talaq, we will see the difference between talaq and instant triple talaq. So when protection of rights on Marriage Act 2019, if it is a compoundable offense, yani compromise can be reached between the two parties at the instance of women. This is written in the act. Okay. So it is a compoundable offense. Murder is a non-bailable where the bail is the and non-compoundable offense because compromise cannot be reached and bail is the discretion of the court. Okay. And cognizable offense, all severe offenses like murder, rape, dacoity, all these are cognizable offense where the investigating officer does not require the warrant to arrest. He will proceed. Normally, non-cognizable offenses are compoundable offenses. Okay. And non-bailable. Non-bailable, compoundable and cognizable. They go hand in hand normally. And most of the civil cases are compoundable. Compromise can be reached and they are non-bailable. Normally इनमें तो अरेस्ट ही नहीं होता है and cognizable क्योंकि अरेस्ट का सीन नहीं है ज्यादा. Okay, other than few cases, check bouncing cases, it can be both civil and criminal, negotiable instrument act. So there are few cases. Okay, otherwise it's not the case. Okay, so now SC/ST में Supreme Court ने कहा before arresting someone under the act, you have to take the permission of SSP. So there was huge protest and finally Parliament amended the law and added कि no preliminary inquiry before FIR and no permission of SSP before the investigating officer can arrest someone. So the judgment of Supreme Court was subverted by an amendment by the Parliament and the amendment was again challenged in Supreme Court. Supreme Court said yes. So they upheld the amendment actually. Okay. So untouchability is not defined in the constitution. Practice in any form is forbidden. It is punishable by law. And what is the name of the law? SC/ST Prevention of Atrocities Act 2019. Subhash Kashinath Mahajan judgment mein SC/ST Act was diluted. It was diluted and now the act has been again restored to the form and the Supreme Court judgment have been subverted by a parliamentary amendment. Okay. Next is 2015 amendment to SC/ST Act. 2015 में SC/ST Act में amendment हुआ. क्या amendment हुआ? A new chapter was added on the rights of victims and witnesses. So the state shall be under duty to provide security to the victims as well as witnesses. A new chapter was added on the role of public servant. Every public servant shall read out the FIR, give the copy of an FIR, okay. And new offenses were added. जैसे garlanding SC/ST with footwear, sexual harassment of SC/ST women. There is a provision in IPC, but here there are more stringent provisions. For example, social economic boycott of SC/ST, and this act is only applicable on non-SC/ST. This act is only applicable on non-SC/ST. It cannot be applicable on a member community of SC or ST. So this is the recent change to SC/ST Act. Also the Supreme Court judgment in Subhash Kashinath Mahajan case, what the parliament did to overturn the judgment of Supreme Court. What is the stand of Supreme Court on untouchability? It has wide manifestation. It is not only concentrated to SC/ST, but other also. And I gave you an example from one of the paragraphs of Sabrimala, that is Young Lawyers Association judgment. Okay, so this is the entire, and deliberately the Constituent Assembly left the term untouchability undefined. Ki untouchability in any form is forbidden and practice is punishable by law. Okay, so Constitution punish nahi karta. For example, bonded labor. It is Article 23. So, but you have Bonded Labor Abolition Act, Immoral Trafficking. So, you have Immoral Trafficking Act. Okay, so Prohibition Act. Child labor, you have Child and Adolescent Prohibition and Regulation Act. So, Constitution provides for the provision. Punishment is provided in an ordinary law passed by the Parliament. Okay, so you got Article 17, which is relatively an easy one. पर इसमें facts ज़्यादा है. Mains पे एक question इस पे बन सकता है. Please write. Article 17. Untouchability is abolished. Article 17. Untouchability is abolished and practice in any form is forbidden. Untouchability is abolished and practice in any form is forbidden. Untouchability is abolished and practice in any form is forbidden. Full stop. It is also punishable in accordance with parliamentary law. It is also punishable in accordance with parliamentary law. It is also punishable in accordance with parliamentary law. Next point you write. Untouchability has not been defined in the Constitution. Untouchability has not been defined in the Constitution. ठीक है? Can I make this statement कि untouchability, abolition of untouchability is absolute and it has widest amplitude? Please write. Abolition of untouchability is absolute. Abolition of untouchability is absolute. Abolition of untouchability is absolute and is of widest amplitude. Abolition of untouchability is absolute and it is of widest amplitude. Okay, next you write. The Parliament has enacted SC/ST the parliament has enacted SC/ST bracket में prevention of atrocities, close the bracket, Act 1989. SC/ST Prevention of Atrocities Act 1989. SC/ST Prevention of Atrocities Act 1989. अब इसमें जो recent change हुआ है from मेंस perspective, you please write new changes. A लिखिए, A. New offenses have been added. 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 A. Garlanding SC/ST with footwear. Garland मतलब, please write garlanding SC/ST with footwear. Garlanding SC/ST with footwear. B. Compelling manual scavenging. Compelling manual scavenging. Garlanding SC/ST with footwear. B. Compelling manual scavenging. C. Threatening or imposing social boycott. C. Threatening or imposing social boycott. D. Threatening or imposing social boycott. C. D. Sexual exploitation of SC/ST women. ज्यादा तेज जा रहा है क्या जी? क्रांतिवीर सब हो गए ना, अब ऐसे ही चलेगा मेरे साथ भाई. आप लास्ट में जब आपका ये कंप्लीट होगा, जब व्हेन आई कंप्लीट दिस, यू डू वन थिंग, जस्ट टेक द नोट्स, ओके, एंड एनी नोट्स यू सी इन द मार्केट ऑफ पॉलिटी, हैंड रिटन नोट्स, नॉट ऑफ पबैड, you just go and compare what is the content, basic. I'm trying to incorporate everything, current affairs also, recent changes also, and much beyond. जो भी possible है, you can go and compare anytime. Any note that is available on Polity, any note, you just go and see what is the content and what has been given to you. Article 12, definition of state, R.D. Shetty case, Article 13, all the provisions, Clause 1, Clause 2, or ordinances, bylaws, all these things. ठीक है, लिखिए. Garlanding SC/ST with footwear. Last point क्या था? Sexual exploitation of SC/ST women. And then you write preventing SC/ST from places of public worship. Preventing SC/ST from places of public worship. Preventing SC/ST from places of public worship. हो गया. अब लिखिए रोल ऑफ पब्लिक सर्वेंट डिफाइंड. रोल ऑफ पब्लिक सर्वेंट डिफाइंड. मैंडेटरी रजिस्ट्रेशन ऑफ FIR. मैंडेटरी रजिस्ट्रेशन ऑफ FIR. Giving a copy and mandatory reading out of FIR. Giving a copy and mandatory reading out of FIR. Okay. ठीक है. Giving a copy and mandatory reading out of FIR. उन्होंने क्या बोला और आपने क्या केस दर्ज किया? What the complainant said and what FIR you have launched. So actually, complainant said something different. You diluted the provision, and you're getting my point. So this is not good. Okay. So please write a new chapter on the rights of victims and witnesses. A new chapter on the rights of victims and witnesses. A new chapter on the rights of victims and witnesses. ओके, नेक्स्ट यू प्लीज राइट. अब ये हो गया, ठीक है. यू प्लीज राइट नेक्स्ट. द सुप्रीम कोर्ट इन सुभाष काशीनाथ महाजन केस. The Supreme Court in Subhash Kashinath Mahajan. The Supreme Court in Subhash Kashinath Mahajan case ruled that A. Preliminary inquiry by a DSP rank officer. Preliminary inquiry by a DSP rank officer preliminary inquiry by a DSP rank officer, preliminary inquiry by a DSP rank officer before registration of FIR. Preliminary inquiry by a DSP rank officer before registration of FIR. Okay, then you write the consent of SSP before arrest in case of a private individual, the consent of SSP before arrest in case of a private individual, and appointing authority in case of public official. And appointing authority यानी एसएसपी का परमिशन चाहिए प्राइवेट आदमी को अरेस्ट करने के लिए, और अपॉइंटिंग अथॉरिटी इन केस ऑफ अ पब्लिक सर्वेंट. एंड अपॉइंटिंग अथॉरिटी इन केस ऑफ अ पब्लिक सर्वेंट, यानी पब्लिक सर्वेंट को अरेस्ट करना है तो अपॉइंटिंग अथॉरिटी, यानी आईएएस को एससी एसटी एक्ट में अरेस्ट करना है तो प्रेसिडेंट इज द अपॉइंटिंग अथॉरिटी. सो इट फाइल विल गो. सो हाँ, so this was actually SC/ST Act पे ये एक major. Please write, there was protest and the parliament amended the act, and the parliament amended the act that and the parliament amended the act that and the parliament amended the act that बताइए क्या, there is no need for preliminary inquiry, there is no need for preliminary inquiry there is no need for preliminary inquiry before registration of FIR. There is no need for preliminary inquiry before registration of FIR. And no permission required no permission required by the no permission required by the no permission required by the SSP before initiating an arrest. No permission by SSP before initiating an arrest. एक और प्रोविजन पार्लियामेंट ने ऐड कर दिया, provisions of section 438 of CRPC, that is anticipatory bail shall not apply to SC/ST Act. यानी anticipatory bail. Please write. जी, अपॉइंटमेंट अथॉरिटी जो सुप्रीम कोर्ट का जजमेंट है कि अपॉइंटमेंट दिस ओल परमिशन ही खत्म, तो ना एसएसपी और ना अपॉइंटिंग अथॉरिटी. ओके, अभी अब नो परमिशन. इट इज अ कॉग्निजेबल ऑफेंस. इन्वेस्टिगेटिंग ऑफिसर विल गो अहेड एंड अरेस्ट इररिस्पेक्टिव ऑफ द पर्सन. देयर इज नो नीड टू टेक परमिशन फ्रॉम एनीबडी, क्योंकि इट इज लॉ, एवरीबडी इज इक्वल before law. Okay, that is equality before law in criminal. So it is now, its whole permission has been done away. Now you write section 438 of CRPC. Section 438 of CRPC, that is the provisions of Section 438 of CRPC, that is the provisions of anticipatory bail. Section 438 of CRPC, that is the provisions of anticipatory bail, shall not apply to the act. ठीक है, Section 438 of CRPC, that is the provisions of anticipatory bail, shall not apply to the act. एक last factual information, UPSC is asking payroll और ये सब, so you write this act is not applicable on SC/ST. This act is not applicable on SC/ST. Yani if an SC is accused of a untouchability against ST or ST against SC or SC within SC, then it will not be. So you can, UPSC can give a very plain statement कि SC/ST are exempted. SC आपस में if there is an untouchability, this act will not come. Okay, you're getting my point, na? This act is not applicable on SC/ST. So it is only applicable on outside. Getting my point? And so you are getting this, na? Any public official का role बहुत ही strong है. FIR दर्ज करना है and you have to read out the FIR and give a copy. Okay, and the untouchability has been manifested in a widest of amplitude, including untouchability in any form. So SC/ST की कोई दुकान है, there is a grocery store, deliberately you are not buying from there, so it is a form of economic boycott. This can also lead to a registration of FIR. So this act is actually a very, very stringent legislation, okay, and that is required also, okay. So we have done this. Now we have a easy article. अब मजा आने वाला है, क्यों? We'll be doing Article 18, Article 19. 19 is so 3 roadblocks are there. Article 16, Article 19, Article 21. 16 is biggest roadblock, 19 is ठीक ठाक, 21 and 25 सबसे बड़ा roadblock है 25. Secularism, Sabrimala verdict, triple talaq verdict, Shaira Bano verdict, Shah Bano verdict, all the verdict. What is secularism? What is the ambit of secularism? Okay, so it will take, जैसे आज पूरा 16 ही किया हमने. So ठीक है, तो we'll take a break and meet after 5 minutes. So please, thank you. Have a wonderful evening. Take care. Bye.